the Minister.
Sir, at the outset, I would like to thank those 7 members who participated in this debate and rest sitting here even without participating.
And listening.
So I must thank them more than those who spoke. And we have heard, sir, though about an hour was given to this bill, we almost taken more than 2 hours. And I was really happy that many points were made worth consideration. Now, I do not have the legal or a language competence to mete out the arguments of Banatwala ji or Pramanik ji, but with all Pramanikpana, with all honesty, I would like to react to all points raised and put up the government's viewpoint on it. Sir, the first speaker, Honorable Nachippan, has made a point that as far as selection of persons on the appellate board is concerned, we have said that somebody who is or already been a judge should be appointed. Now, even in standing committee, he made his point very forcefully, and not only that, the standing committee report shows that he put up a 2-line note of dissent to standing committee for not accepting his viewpoint. But I respectfully disagree with him when he says that I am taking away the chance of millions of lawyers. Frankly, sir, in this tribunal there may be about half a dozen people. So whether I appoint ex-judges or present judges or the persons who are capable of judges, it's a question of half a dozen people. So it's not a question of millions of lawyers are prohibited from being here. Theoretically, it may be right. Practically, we are appointing about half a dozen people on these boards. And here we thought that looking at the importance of technical and legal angle which they will have to look into, we thought that we should select a person who has already gone through a selection process. And that is why neither the committee nor the government could accept the suggestion made by him. And so I would request him that though he put up a note of dissent to the standing committee report, here he will agree with me that I'm not taking right of any lawyer, because even judges were lawyer one time or the other. So I'm not taking rights of the lawyers. So it is nothing against lawyers, against government. The only thing that we thought that persons who have already gone through selection process, it will be better to choose them, nothing more than that. And so respectfully, I cannot agree to his amendment or suggestion. As I said, that I hope that he will respect the standing committee's decision and the other house decision also. Secondly, sir, रासा सिंह रावत जी ने कहा कि हम विश्व व्यापार संगठन के कारण इसको ला रहे हैं. ये तो सच्चाई है, सारी दुनिया जानती है कि हम विश्व व्यापार संगठन में हस्ताक्षर कर चुके हैं और इस हस्ताक्षर के कारण उससे मिले जुले कानून बनाना हमारा काम है और उस प्रकार से हम कानून बना रहे हैं. लेकिन मैं इसमें इतना ही कहना चाहूँ कि हम कानून बनाते समय, आपको याद होगा कि विश्व व्यापार संगठन पे हमने 1995 में हस्ताक्षर किए थे और 31 दिसंबर 99 के पहले हमको ये कानून बनाकर तैयार रखने थे. लेकिन हमने इसमें ऐसी किस प्रकार की कोई जल्दबाजी नहीं की कि बिल्कुल विश्व व्यापार संगठन ने कह दिया तो हम कर दें. विश्व व्यापार संगठन की जो तिथि थी वो भी टलकर आज 8-9 महीने हुए हैं. हमने कानून बनाए, संसद में रखे, स्थायी समिति ने उस पर अध्ययन किया और उसके अध्ययन के बाद अब पारित करने की स्थिति में हम पहुंचे हैं. और इसलिए मैं विनम्रतापूर्वक ये कह सकता हूं कि दो it's true that it's part of WTO agreement, but at the same time we are not blindly following it. On the contrary, Honorable Banatwala ji is saying that we are not following where we should follow the trips. Secondly, the issue raised by him about the product and process patent doesn't come under this law, and so it's a different patents law, and whenever it will come for a discussion, I think the House will have a privilege of his views on that, and then the House can take a decision. So as far as the semiconductor layout design bill is concerned, the process product are not really part of it. He has raised one very important point of reverse engineering. And I can only say that I totally agree with him that the reverse engineering should be permitted. And if you look at the clause 18.8 of the bill, it provides the reverse engineering, where we say that layout design which is identical. When you use the word layout design which is identical, the word identical provides you for the reverse engineering, and so as he has suggested that the reverse engineering should be permitted, it has been already permitted, and his point is well taken before he made it. Adhyakji, Honorable Member Pramanik has made very, very important points as far as this bill is concerned. Now, he also has a privilege of being on the member of the standing committee. And he also forcefully made all these points in the standing committee. But unfortunately, standing committee could not agree with him. He did not attach any note of dissent on this willfully and knowingly, on which Banatwala ji is little upset over this wording. I think this is the contribution of Honorable Member Pramanik to the committee, and committee accepted on his insistence. So it is not that committee did not take advantage of his knowledge in this. I can only one say, sir, that I'm not expert as he is. But if you talk about this integrated circuits, I can only say that these are basically used on a silicon which is a semiconductor. And that is why we have used the word semiconductor layout design bill. I don't think it makes a much difference by deleting or adding the word. Now, I totally agree with Shivraj Patil, because even at the information technology bill also he said that we should find out the titles of the bill in such a way that but just by reading the title, layman should understand what law we are talking about. And he has given few examples, and as I said, I don't have his legal competence, so I can only talk with the legislative department that while framing the titles of the bill, they should take proper care that the name should, as far as possible, tell the whole meaning of the law, and that point is well taken. As far as, sir, the another issue is concerned about chairperson, as I, please.
It's one of the active elements. There are active elements also. Now, in the final act of Uruguay round, there are only integrated circuit, layout, design. Nowhere semiconductor is mentioned. So, semiconductor is one of more active elements. Why it is only semiconductor? There are resistor also, and there is a capacitor also. So, why only semiconductor?
Sir, to best of my knowledge, subject to correction, even advanced countries like USA and Japan, when they have followed this TRIPS argument and made the laws, they also have used the word semiconductor. As I said, I can't debate because I'm not that, I'm just putting up a word. So I don't think by deleting semiconductor and using integrated circuits will make a difference. The second, sir, as far as chairperson word is concerned, I think I already explained when he said that the committee suggested us to change from chairman to chairperson. This applies only in English language, because in Hindi language we don't have to make any change, and it still remains Adhyaksh. It's no gender, but anyhow, you see, sir, it is. Anyhow, but the standing committee insisted on it. We accepted the amendments, as I said, inadvertently, we accepted and changed the law at 50 places. Inadvertently, one place, it was not changed, and I am moving the amendment to change it, and I am sure that Rajya Sabha will agree with it. But I think sometimes, sir, and I respectfully submit to Subodh Mohite that the word he or she, Shivrajji has already helped me in this respect. He has given me advice and help without any fees, saying that the general purposes clause, he includes she, though it should be the other way around, but he includes she. Normally she includes he or woman includes man, but in the clause man includes woman or he includes she. And in standing committee also it was debated. And when it was brought to their notice that this is the reason, and so there is no gender bias into this. And only one point I would like to make it, sir. Our test really lies as a country whether we appoint a woman as a chairperson. Otherwise, every bill is changed from chairman to chairperson, and if only men are appointed on this post, then men will be always there. Your name will be chairperson. So when you say chairperson, if you really, so the test is not notional, whether you are calling he or she or whether you are calling chairman or chairperson. More and more women, if you go on appointing, I think women are more interested in getting appointed on different committees than calling them chairperson. So it's a notional value. We have already changed it. Sir, the third thing about the registrar, I won't take much time because they have raised many points. As far as the appellate tribunal is concerned, these are the statutory appointments. So naturally, their qualifications and everything is written in the bill itself. About registrar, normally rules take care of such appointments, and this, not only in this law, but even patents, copyright, trademarks. I can tell you n number of laws where such posts and their which are not in a statutory or a quasi-judicial nature, those posts are always decided by the government by making rules, and we have taken course to the same. So as I said, I don't expect him to agree with me, but I am telling him the government viewpoint on this. Sir, very important point was raised by Pramanik ji, Banatwala ji and Shivraj Patil ji, and I would like to take little time on that issue because that I think is very important. Sir, that is between a inventor versus a proprietor or a financer or a promoter. Sir, it is true that after all, any intellectual property is the creator's property. It's the creator's property. And so naturally, the whole credit should go to a creator. But as somebody rightly said that you need money also to get your creation into actually a commercial thing. Sir, what we did it here, we are following a general practice in this business, not only in our country, but all over the world. Normally, all over the world, the people who have brightest brain work in different companies, or they are commissioned by different companies, and when they invent, money is paid for them, and sometimes money goes down the drain without inventing anything, or sometimes it is very cheaply invented also. Sometimes you spend few $100,000 and get an invention, sometimes you spend billions of dollars and don't get anything out of it. Under such circumstances, normally the person who is a promoter or who is running a company or who has commissioned a job gets the intellectual property right and not the inventor. Now here what we have done, and I would like really House to try to understand, and if I am making mistakes, Shivrajji can correct me. In 7.3, sir, we have said, where an original layout design has been created in execution of a commission or a contract of employment, the right of registration to such a layout design under this act shall belong, in the absence of any contractual provision to the contrary, to the person who commissioned the work or employer. But if somebody with a brightest brain makes a contract with his employer or a person who has commissioned, look, I can work with you only and only if the rights comes to me. Then even under this bill, if he has a contract, then he can have a property right. But if he doesn't have this kind of a thing, then normally, as I said, business practice says that it should go to the employer or the person who commissioned. Please.
Well, I think you are certainly following the international practice. But is it necessary for us to follow the international practice in all cases? We can go a step ahead of what other countries are doing. Now here, this clause, as you are rightly said, if there is a contract which says that a certain share of the profit shall go to the inventor, it will go to the inventor because that would be registered. But as the situation stands, as the things are there in our country and outside also, it is the money which is dominating. In fact, in the knowledge-based industry or in this area where knowledge is important and the man who is inventing is more important, will it be beyond our ingenuity to have a law which really protects the interest of the person who is really responsible for creating the knowledge?
Sir, I would love the inventor to get the entire credit.
Pramanik, Professor Pramanik.
Clause 7 and subclause 3, my amendment was where an original layout design...
No, I'm not come to amendment, I'm just...
Oh, yeah. Now, only that, now, to the person who commissioned the work or to the employer, in place of this work, to the person who invented. So that is the amendment. You see, this protection is given to the employer. Now the intellectual property, the creation of intellect. So the real protection should go to the inventor, not to the employer. Now employer can get his share by a contract. The provision is there, and there is a contract. So the intellectual property is the right of registration should go to the holder of the right, and holder of the right is the inventor and not the employer. So what's the harm if we change to the person who commissioned the work or to the employer? In place of that, if you write to the person
Please.
who invented.
Please.
Sir, let us agree to disagree. That as I said, that if the law gives all rights to the inventor, I am afraid he would...
If there is a contract that would be shared by the employer, then the employer will get his share. So it has been mentioned.
No, I already said if he enters into a contract
Yes.
with his employer or a person commissioned, then the contract will prevail. No, then now we come to the... So first thing, as far as contract is concerned, that will prevail. So we are not taking so moto the right of the inventor and putting it to the proprietor or the employer. We are not,
He is a weak party.
Sir,
Give
it is
him
all right.
protection.
That's
Give him
why,
protection.
that's why I said, let us agree to disagree. I too agree with you, sir, that it is a weak party. But at the same time, this weak party to produce something worth intellectual property right needs money. Suppose by law I make it and tomorrow the companies don't come forward to make financing, then again there will be a problem. So what I said here, that look, if he thinks that he has something which he can make a contract, some novel idea, he can even under this law make a contract and get money whatever he wants with it. But I can't so moto say that the employer or the person who is commissioning will not have anything and everything will be left to the inventor. That is not an international practice.
Share is there. In the subclause, the provision is there. The
That is what
employer
I'm
will
saying.
get his share.
Please listen to Minister's
Yes,
reply.
sir, I
If you have
go.
any questions, then you can ask afterwards. Please.
Secondly, sir, no, I think I have already answered many things. He said that why do you take 62 years? No, why not 65? Frankly, sir, in appellate board and all tribunals, the 62 years is normal practice. If it is left to me, I would like to go a little down, not to the upside of 65 or 70. Now, it's in young India. This is the youngest industry, so we must appoint people who are little younger. So please don't ask me to raise this from 62 to 65 the other way around. Sir, now I come to Honorable Member Subodh Mohite has gone. But anyhow, sir, as he rightly said, sir, there are some spelling mistakes into it, and though minister may not directly see it, but when it comes to the house, I am the responsible person for even spelling mistakes, and I really apologize for the original spelling mistake in the law, because the word original has made a spelling mistakes. Secondly, sir, he has asked only one thing, that whether he will have a right from the registration or filing. He will have a right from the filing the application for 10 years. But it will be only given to him if it is registered. So the period between filing and registration will be his right, but the only thing, he should be registered. If suppose for any reason he is not registered there, then naturally filing doesn't give him a right, but he has asked this question. Secondly, one thing he said, I think after finding out couple of spelling mistake, he went very almost only on the words. Sir, in miscellaneous, national security is mentioned. It's not true, because when you write a law, you have a subject heading, and when there is no subject heading left, but few important things are left, then you said the subject heading is miscellaneous. So we are not taking national security as a miscellaneous subject. It's a very important subject, but under the headings it naturally comes into miscellaneous because of the style of writing, and so I think he will accept this. Shivraj Patilji has said about the title of the bill, I have already explained. Number, I think, one thing he says, it is true, sir, that this bill protects the designs, normally, which is a software activity. But in semiconductor layout design bill, this design get converted into chips, which is a hardware activity. So at least this bill doesn't only support, it supports both. But I will take your point, sir, and which is very important, though may not be directly related to the present bill, that India has to concentrate in future, if you really want to become a global power in information technology, on IT. If you just, because just recently I had been to China, if you look at India, in a software, we are already a global power. But if you look at the hardware, definitely we are lagging behind. And for somebody to be a real global power or an influential global player, your development cannot be lopsided kind of a thing. So hardware has to be concentrated, but as he rightly says and knows, that hardware needs a lot of investment. It's not that easy to have that kind of investment, but definitely at a government level or a public sector level or private sector level, we will have to take initiative to strengthen the hardware development in this country, and he has made few valuable suggestions like Northeast or where you can't have another kinds of business, but where you have educated people, a good environment, and we should exploit these situations and make us a hardware power. That point is Murthy ji has also said about the gender and grammar, so I already said about it. Now, sir, lastly I come to a few of the very important points made by Banatwala ji. I am not coming lastly, but he was the last speaker, so and last is always very important, sir. I already told you that this is a WTO compliance, but on our own time. Sir, he has raised 3 or 4 points about inventor and promoter. I think already explained my position. He said, why period of protection is 10 years when the TRIPS agreement permits you for 15 years? It's a very valid question. I'm not sure whether I should articulate very freely in this house or not, but I'll try to tell you. First thing, sir, this is the fastest moving technology where the life cycle, which was 6 to 8 years, have come down from 3 to 5 years. So really 10 years is also a lifetime as far as this technology movement is concerned. So 10 years is more than that. Sir, as I said, I'm trying to articulate, but at the same time I have little hesitation, and I request members to understand what I'm trying to tell. Sir, this is in India's interest. I don't want somebody to register in this country and get a right for 15 years. And the registration done by Indians and non-Indians, if you look at the proportions, then Indians don't dominate these kinds of technologies or invention at this nature. And if I give the right, which TRIPS permits me to give, because I'm not fighting on whether 10 or 15 years. If I give the right to 15 years, it is not right only to Indians. Anybody who registers here gets the rights for 15 years, which I really don't want, because most of us use it, not invent it. And so, I can't be more clear than this in the House, and I hope House will appreciate that using 10 years is a pro-India line, because that will go in our, because somebody registering here, instead of getting 15 years protection, he will get only 10 years protection. So, on 11th year, anybody and everybody in India can use, and I think this goes in India's favor, and that is the precise reason. It is also 10 years, sir. Many countries have done it 10. Yeah. Yeah. Sir, as far as the compensation issue is concerned, I can say that there are two types of things done in this. First thing, if somebody unknowingly infringes the intellectual property right, then we have provided, A, he can go for a settlement. B, if they can't go for a settlement, he can go for an appeal, where the appellate body can give him a royalty. Now suppose, sir, he says, no, I did not do it. Then the criminal procedure is there. Now in the criminal procedure, both things are written, that there can be imprisonment or a fine, as usual you write in such kind of legislations. Now, I am sure, sir, if you look at these kinds of legislation, nobody would like to face imprisonment. I am very sure that even the provision of imprisonment to the type of the people you are likely to deal in such kind of legislation, they will go for any settlement of a royalty instead of going even one day for a jail. Now, as far as giving compensation out of that penalty is concerned, because Honorable Banatwalaji has moved also one amendment, that you should say that out of this penalty, compensation should be given to the person whose right has been infringed. There I can only draw the attention again that in CRPC there is a 357 section which talks about order to pay compensation. And in this order to pay compensation, when a court imposes a sentence of fine or a sentence including of death, of which fine forms a part, the court may, when passing judgment, order the whole or any part of the fine recovered to be applied, or in payment of any person compensation for any loss or injury, so on and so forth. So there is already such kind of a provision, and making provision here, we thought that was not necessary. Sir, I tried my level best to answer, or I don't say answer, to give the government sides of the objections raised here. I again thank all the members for supporting it, and I hope that now Banatwalaji late in the night or Pramanikji will not insist on moving the amendments and pass it with only government amendment.